Okay, good evening, all of you, and thank you for joining us. My name is Aravind, and I'm extremely delighted to welcome all of you to our third webinar as part of a new Right to Information series called Conversations on RTI, which is being anchored by Shailesh Gandhi, sir, who's a very well-known activist, RTI evangelist, and a former Central Information Commissioner. We're extremely happy to have with us today Professor Dr. Sridhar Acharyulu, who is himself a leading legal luminary and one of the most pro-transparency commissioners we've ever had. He has been instrumental in passing some really remarkable orders during his tenure at the commission. So allow me to take this chance to thank both Shailesh sir and Professor Acharyulu for joining us. So thank you for joining us. For those of you who are new to us today, Moneylife Foundation is a not-for-profit organization that's primarily engaged in spreading financial literacy and advocacy for savers. Our Right to Information Center, which is being supported by the Thakur Foundation, has been doing its best to promote the use of RTI in various ways, including the RTI app, which now allows you to ask questions about RTI to a panel of experts in any language by text, audio, or a video. My colleague Akshay will be sharing a link of that in the chat in case you wish to download it. So please do have a look at that and do definitely download that. Before we officially begin, allow me to take this chance to share a couple of rules that we need to follow. We've kept all of you on mute during the session. This is for the benefit of the speakers and the participants involved, and we'll unmute you during the Q&A. For optimal viewing, I'm going to request you to keep the webinar on speaker view. This meeting is being recorded, and a copy of this will be uploaded on our YouTube channel, Moneylife TV. So you can always look back at that video. Also, during the Q&A, please use the raise hands button option that's available on Zoom. It's available in the bottom if you're on your laptop, and if you're on your phone, you can see that in the bottom too. Please feel free to use this chat section to share your comments, questions, observations. But as a sincere request, please do not send it to us in the private forum. Please send it only in the public forum. We will not be able to respond to private messages. Also, I'm going to request all of you to keep your cameras switched off during the course of the discussion so that your privacy is intact. I think without taking too much time, I'm now going to have to request Gandhi sir to take over. Sir, over to you.
Thank you, Arvind. Sridhar Acharyulu is a very good friend of mine and one of the few information commissioners I truly respect. But he's had a very interesting career. He has at least 3 roles that I know of, and there may be others. He's a very good journalist, a very good commissioner, and now, not now, even earlier an academician. I don't know which role he does best, but as a commissioner, he certainly did very well. What a lot of us do not know is that one of the first usages of RTI was done by his friend Sridhar in 1986. Yes, much before we made the RTI Act. If I recall correctly, that is the year that Justice made the first proposed bill for RTI. Sridhar was actually using it. And Sridhar, could you share the experience with us?
That's a wonderful memory of my experience also. I was an investigative journalist in a Telugu newspaper. I went to Tirupati, though it was not my area of duty. I was supposed to confine to Hyderabad only. But I took some curiosity, out of curiosity, I took some interest in probing into the activities of Tirumala Tirupati Devasthan, the richest temple trust in the country after Thiruvananthapuram. So I found lots of irregularities, financial irregularities, and new schemes like pre-qualified contracts. In the IT5, people do not know what is pre-qualified contract. At the time, they have introduced it. And with that, they have finished off the small contractors and benefited big, very rich contractors, giving them 40% advances. You know, they themselves give 40% advance, and then bank advance also will be there. And they'll be constructing the buildings which are designed by the TTD. So this, I found it very scandalous. And then when I started collecting the information, it was really revealing. Then I filed 9 investigative reports in my newspaper the circulation of which was gone simply because of my reports, gone by thousands of copies extra. Then Chief Minister N.T. Ramarao was very angry because I was exposing one of the very, very prestigious temple trust. Then he ordered a judicial inquiry into it. That was a good thing he did. And then what he said was, the person who reported it must prove it. He said he will not appoint anybody to get into these things, and the person who reported, that is Sridhar, has to report it, has to prove it. Then my newspaper management also said, because you wrote, please do it. We'll support you. Luckily, they supported me. Then when I was in Tirupati for attending the Commission of Inquiry, I wanted to see the files of the contract engineering, chief engineer files of contracts under TTD. I made an application, interim application before the judiciary, before the High Court, retired High Court judge. Then he said, we never had such a thing happened in this country. Nobody asked for inspection of a file. They said, I'm asking, now you decide, I'm asking for it. Then the executive officer is an IAS officer, because it's a very rich temple. Government appoints a very senior IAS officer who is of the cadre of chief secretary, almost chief secretary. So he was a very influential officer. He said, it's my file, and who is he to ask for it? I said, who are you? I said, who are you? You are an executive officer of a trust board. You are not owner of the files. You are not owner of the money. I am the owner of the money, because I donated 100 rupees whenever I go to Tirupati. I donated 100 rupees. I am the owner. I am the devotee. I am the reader. I am the general member of a public. It's my file. That was my argument. And fortunately, argument was accepted. And then they gave me the chance of inspecting thousands of files. And each file was consisting of thousands of pages. Then it was a Herculean task for me. I don't know what to do. But luckily, I could lay my hands on one of the files in between, just like that, random looking at a file. And then a cursory reading of that file made me to discover very incriminating documents. And by the end of the evening, I could discover 385 documents, which are very useful to establish what I have made in my reports. All my allegations could be proved with those copies. So nobody can say that I am factually wrong. So around 385 documents are list of the documents I made. I went on writing on a page, at the time, the computer was also not very popular. There was no computer at our availability. So there was a copying facility, but I went on writing on a white paper. And the two sides of the white paper were full of the numbers and pages. So the list of 385 documents was ready. The next day, I made an application for photostat copies signed by the responsible authority. I didn't say certified, but I did not use that word. Signed by the responsible authority, it should be there, handed over to me. Then again, the arguments went on, very fierce arguments. They have appointed senior lawyers of the state. And then I was also supported by one lawyer, but I was feeding him complete information. At some points, the judge asked me to explain. I went on explaining. And again, the same points were raised. Who is the owner of the files? I said, who are the owners of a temple? Lord Venkateswara is a legal personality. He is the owner. And you are a trustee. You are a manager at the most. You are an officer who manages the trust office. So you have no right to deny inspection of files and copy of files to me unless there is a scandal. Then they gave me all 385 documents, and I could prove. And the record of my submissions and the list of documents is available in Andhra Pradesh Assembly now. That report is the proof of my work.
Very nice. This is the first major use of RTI that in the country that I've heard of. Tell me something now, going to another topic. Sridhar, you've been a commissioner yourself. You observed other commissioners, been a colleague of theirs. What do you think are the qualities that should be looked at before selecting an information commissioner? What are there's no criteria right now. It's eminent. Everybody is eminent in this country.
Eminent
what do you believe are the necessary and the possible desirable criteria for selecting a commissioner?
It's a very, very vague expression, sir. Whenever there is a vague expression in law, it gives huge discretion to the authorities. Out of uncertainty and undefinability of a term, the officer assumes more powers, extreme powers, and he can do anything, and it will be covered by that. That is the problem of the clause that empowers the government or gives a huge power to the government to appoint anybody from those 10 subjects, rather around 9 subjects were explained in the Act. So eminent persons from that have to be selected, but they did not even follow that literally. Forget about the vagueness of the expression. But when there's a clear mandate that you have to select commissioners from those subjects, they have completely ignored some of the subjects, and they have totally depended on 1 or 2 areas of like administration and management experience. That's all. They picked up commissions, 90% of the commissions, at least roughly speaking, are picked up from that category only. And very rarely people like you and me are appointed. It is a very rare thing. And you came on invitation, but I was surprised to become a commissioner because I made an application and forgot. Nobody was there to take my application to the authorities. I requested some of the MPs to take my application, but nobody did it. Then I simply forgot it. Then I was surprised when I got a call from the PMO that you are appointed.
Okay, now let's, Sridhar, a lot of things we agree on, but there are certain interpretations of the law where we disagree also, which is how it should be. Let me ask you a few contentious things, and how do you interpret this? 2F says information relating to any private body, what is right to information, which can be accessed by a public authority under any law for the time being in force. Now, some people say, therefore, any information about a private body should be available to me. For example, the income tax authority can ask for any bill. Is that the right position, or what should be the right position?
See, the position is this. The whole information is available with the private bodies only. Very, very little information is available with public authorities of their own. But most of the public authorities are regulatories, and there is a statutory duty cast upon the private bodies to submit certain reports to various authorities. These are the reports available with the public authority. So they are supposed to share it. That's what they are saying. They are not saying that entire public information has to be in public domain. Entire purpose, objective, and declared the target of the Right to Information Act is to provide access to information available with the public authorities. So a public authority, if it has authority to collect a report from a private body and it's available with them, they have to give. Even without this definition, it should be made available to us. Even without this sentence, the last part of definition of information, the citizen is entitled to it. But to make things clear, the definition was drafted very well. And they said, if private information is accessible through a legislation, then I'll give you an example. There is one law called Society Registration Act in 1860. And it clearly provided for right to information and access to information held by the society in the society's registrar's office. And they also prescribed fee of 25 NP, 1860 25 NP. Till today, it is the same. In one of the orders, I said you should collect only 25 NP and give the entire information. I gave an order because the interpretation of the high courts of this clause was very discouraging. In my view, if information is accessible through a legislation in force, that information is part of the definition of information. That means what? The entire RTI Act can deal with it, and every information commissioner can direct that information to be given. Even if the RTI application was not filed through a public authority, even if it is filed against the private authority, if law provided for access to that information according to this definition, I think everybody is entitled. But courts said, the courts gave a limited interpretation, restrictive interpretation. What they said is, okay, yes, you have access, but that access should be guided by that enactment, not by RTI. That was not correct interpretation according to my understanding. But whatever courts say, that becomes law according to Constitution. So I used that also. What I said is, one private school was denying the information in Delhi. I said, you are a school regulated by Department of Education, and you have submitted these reports to Department of Education. Then why are you hesitating to give the copy to me? Then they said, no, we are a private body. We do not fall under the definition of public authority. Then I said, are you run by a society or not? They said, yes, we are run by a society. Then I showed the 1860 Society Registration Act, and I made them to give information. Another great experience of mine is, and I think that's a correct position of law. Even today, it was not overruled till today. That is, a private hospital was sought to give information about the medical records of a father of an advocate. Advocate was the petitioner. That hospital said, I am a private hospital, I refuse. Then I used the definition which you have quoted, the definition of information, which says that if any other law provides access to information held by private bodies, it also can be sought under RTI Act. Then I said, I researched. That research resulted in discovery of the Medical Council of India Act and rules made thereunder. According to rules made under that law, if a patient asks for information about medical records, patient or his legal representatives ask for it, they have to deliver it within 72 hours. And there should be a mechanism in every hospital. Every doctor, they don't even say hospital, every doctor they say, whether private, public, RMP or PMP, whoever is the practicing doctor, is supposed to deliver the information within 72 hours. Then I collected various other examples and rules from different jurisprudences, and I presented a very big judgment. I was accused of giving large judgments. I was doing it because I know that I will never be allowed to argue or to defend my case, and I do not know whether anybody will defend my case. So I thought I should incorporate all those supporting points, merit points, if there are any, in my judgment itself. If somebody reads it, some advocate reads it and finds it as legitimate point, he can put it before the writ petition. That was my idea. So I gave long judgments, and it is another 50 to 60 page judgment wherein I explained why this information has to be shared. And luckily, the principal secretary of medical and health was given this report by the principal secretary of law at that point of time. Somehow that law secretary came into contact with me. Then he casually asked what kind of a judgment I gave. I referred to this. He was curious to know about it, and then I shared a copy with him. And the copy was sent to Principal Secretary Health and Health Services, and he was instructed to give the copy of this judgment to all the hospitals in India, to say that every patient has right to medical records of treatment. But you know what is happening. And the man went in appeal. The hospital, private hospital, went in appeal to Delhi, not appeal, writ petition to Delhi High Court. And Delhi High Court said, did you give the information or not? He said, no, sir, I yet to give. Now you give the information, I will defer the hearing of the case. So he was asked to give information at the threshold of the writ petition. That should be the right course of action expected of higher judiciary. I hope everybody will do like that.
So there's a letter that has been written by 15 of us to the Chief Justice. Would you like to talk about that briefly?
Yeah, you have raised a very, very pertinent point of difference between writ petition and appeal. RTI Act is damn clear on the one point that there is no further appeal available and over and above the judgment of Information Commissioner. Where there is no possibility of appeal, there is only one possibility of filing a writ petition for a judicial review, which is a general basic constitutional proposition and basic structure, part of the basic structure of the Constitution also, judicial review. Because the Information Commission is a legal statutory authority, the decision of any statutory authority can be reviewed. The statutory authority includes even President of India. You know, S.R. Bommai case says, even if President of India takes a decision, we don't question him, but we will review his decision. So that's how everything has come under judicial review, and I agree with that. It's a most important, profound federal constitutionalism-based rule. I welcome it. But the process of judicial review is about the process of legality, legal process of the judgment given by the authority, order given by the authority. If the order given by the authority is legally flawless on the point of procedure, writ petition cannot lie. Writ petition, in a writ petition, high courts cannot enter into the merits of the order. They can't increase the fine or reduce the fine, or they can't reject, or they cannot annul the notice issued for penalty, show cause notice issued for penalty, or they can't say that the information disclosable it is not disclosable information, so don't give information. They can't do all these things. They can't enter into this debate at all, because the jurisdiction of the judiciary was excluded when you created a separate tribunal. And that is the reason why the government in the recent days is starving the tribunals and abolishing appellate tribunals. If you have noticed, 9 appellate tribunals were abolished, and 240 vacancies are deliberately kept in tribunals, because they know that High Court's jurisdiction authority of the examining the legality of the orders is being exercised by the independent tribunals, and they don't want that independence be left with tribunals, and they want it to go to High Courts itself. Finally, High Courts. And High Courts, you know, there are 455 vacancies in High Courts positions. So when this fellow's judgment will come, you imagine a situation where Information Commission is abolished. It is almost like that. If Information Commission is abolished, where is it the person whose information was denied by First Appellate Authority should go? High Court. Now, is it possible for the information applicants to go to High Court and get relief? They cannot. So what is it we have ultimately done? We have denied the justice. So this happened to censorship, cinematography censorship board. It happened to income tax appellate board. It can happen to so many other boards, patents board, and so many other things.
You mentioned, yeah, sorry.
One point. So my point is, as far as High Courts are concerned, they have to be confined to judicial review of the legal process. They can't go beyond. Then coming to Supreme Court, sir, this is the issue. Supreme Court has a wider discretionary power, and to do complete justice, they were given extraordinary powers to say anything. So to do complete justice, they can say anything, and whatever they say becomes law. That's required in a democracy like India. But if that is used to stop the disclosure of the information, and that is used against transparency, that is used against information legislation, I think it's a very pathetic state, very, very sad state of affairs.
Your view about the PM Cares Fund, is it a public authority?
Look at the name, sir, PM. It is not Modi Care Fund. If it is Modi Care Fund, we would have not asked for it. It is Prime Minister. And Prime Minister is a public authority, constitutional authority. And then who is the controller of the entire fund, sir? It is again Prime Minister. Prime Minister is the executive head of the trust, and it is handled by the ex officio secretaries in their ex officio capacity. That means if he is not a chief secretary or a principal secretary of a particular department, he cannot touch it. That means what? You are using the public authority, you are using the authority conferred by the Constitution, and you are operating in public domain, and you are collecting the donations because it is a PM Care Fund. If it is a Sridhar Care Fund, nobody will give donations to it. So you are talking about your authority, you are using your ministry, you are using your websites, official websites to advertise and ask for donations. Then how can you escape the responsibility of being accountable and transparent? That is one thing. Secondly, recently they have agreed it's a public trust. So let it at least go with public trust. Public trust means what? You hold the entire money of the donors for the welfare of the beneficiaries. In a trust, in a contract, only a party can ask a question. But in a trust, beneficiary Trust board directors, members, and owners who created the trust also can question. And beneficiaries include general public. Anybody can question. So even without Right to Information Act, simply because you are a public trust, you are supposed to answer accountable and be transparent. That is one aspect. Then I have another very important point. Going by the definition of public authority, the control decides, control, not substantially funded. They are exclusive, no? R, they are separated by O or R. So when they are separated by O or R, when there is a control, visible control of the public authority over the fund, they are public authorities. They can't escape. They are supposed to give. But unfortunate that we are not in a position to ascertain these aspects in a court of law because of COVID. COVID also helping against RTI. COVID is against RTI.
And so the major political parties of the country, as far as I'm aware, they are disobeying the order of the commission, not even challenging it, not even challenging it anywhere.
Yes, sir. Absolutely. It's a defiance. It's a defiance of the CIC order, which became unappealable now because of various other, the lapse of time, because of lapse of time. And there is no complaint. There is no petition. I was arguing with my co-commissioners when I was in the CIC. When they said it is being considered by the Supreme Court. I said, what is being considered by the Supreme Court? Not a challenge. There is no challenge. Read the petition. Then when I brought the petition and read out in the meeting, they understood that there is no challenge. When there is no challenge at all for the last so many years, how can you say that somebody has objection to it? Why the political parties did not challenge it in the Supreme Court? They have to obey it because they have not challenged it. By silence, they have accepted to the decision of the CIC.
There is a provision in law which says that if matter concerns life and liberty, the information shall be provided in 48 hours.
Correct, sir.
And I think you and I disagree on this.
No, I'm agreeing. But on one adjective that you have made,
we have some.
That only. Your orders are very well articulated and legally strong, sir. That's what I would like to place an appreciation for you. And
so
I was
what should constitute life and liberty?
Let me tell you, sir. I was surprised when you have used your general understanding of law so perfectly. And the best example I can quote, which is very legally strong order from you, is that case about Reserve Bank of India, which was word by word supported, upheld by the Supreme Court twice, not once, twice. So that goes to your credit, and I appreciate you for that. And today, if banks are still fighting against that, it is only because the strength of the order, that strength was supplied by you. Here also, you were very reasonably on liberty related information also, but you said there should be a grave threat to life. That's where I differ. If the petitioner proves a grave threat to life, then that related information has to be given within 48 hours. So whenever we add such adjectives, sir, law becomes weak. That is my appeal to you and even the High Court and Supreme Court also. That is the point. Otherwise, if it relates to, so it is concerning, that enough. A concern and a relation has to be established. Then I am entitled to a life and liberty related information within 48 hours. And if commission or for any authority for some reason doesn't understand or doesn't consider it as a life and liberty related information, at least they should give in 20 days or 29 days or 30 days.
In 30 days, of course, it must be. But I wanted to ask you, have you come across any case where 48 hours information has been provided?
Never. And sir, another point I'd like to tell you. Until I raised this question in CIC, there was no mechanism for receiving a complaint that information was not given in 48 hours.
48 hours.
Yeah, they were not given. And when I was discussing the norms and rules, do you know what was the opposition I faced? No. Registrar will decide whether it is life related. And I said, who is the registrar to decide? What is his authority? Then what is that he is supposed to do? Then I said, whenever a petitioner claims that his information request was life and liberty related, it should be immediately sent on that day on priority to the concerned commissioner. And commissioner will decide whether it is to be notices should be given or not. And commissioner has to give notices in minimum possible time. If you can reach the other party within 1 week, don't wait beyond 1 week. That was the norm I have created. I fought for it in 4 or 5 committee meetings, and ultimately they have accepted it. And a mechanism is now visible in the CH. I don't know whether it is still there, but it is there, and we have made certain norms on that during my term of office. And I fought, and I not fought, I can say I pleaded. I repeatedly talked about it, and they started saying that it was my class. 48 hours class is Sridhar's class.
Okay. On the RBI that you mentioned, one of the participants today, David Briskina, has felt that the Commission's orders were wrong on the following counts. One, he says the US law exempts information relating to regulatory bodies in financial matters. Therefore, how can you rule like this and ask for information to be given? What do you feel?
See, sir, India's Right to Information Act is the best because we don't have such a provision. Number one. Number two, when you are a regulatory and financial irregularities are coming to your notice, you don't take action, you don't inspect, you don't share the inspection reports, you don't collect back the people's money evaded by the big businessman. It's a crime. It's a crime, sir. And crime, when you have authority to tackle the crime with your regulatory power, you are performing a public function. And there it is not, it doesn't remain a financial matter, sir. It becomes a matter of ascertaining the power of the state against the criminal. It is a criminal power, sir. And basic power of the state is to see the crimes are prevented and criminals are punished. That is the basic power of the state. And judiciary, when it enters into the mechanism of adjudication of justice, it is open body, sir. It is the openness of judiciary is an established norm over centuries, not constitutional power, sir. They are supposed to be open. They were open since centuries. In a public meeting, the justice was being dispensed. They are supposed to dispense justice only in the public sphere, public in openness, transparently. Every trial has to be done in open, and exception is in camera. So this is the real right to accountability of the people against the judiciary. It is the real power of the people to seek accountability of why the adjudication is being happened in public, sir? Only to have public scrutiny. The people have a right to have a scrutiny of the judicial proceedings. And when a financial matter gets converts into a financial indiscipline and financial crime, when it is supposed to be probed, examined, and to be tried before the court of law, how can it become a confidential matter? How can it become a financial matter? It will never be considered as a financial matter.
He also raises an issue about one commissioner. I was a single commissioner sitting in that bench, disagreeing with the order of a full bench, including the chief commissioner, which is what I had done. And I'll explain the reasoning for this. The previous order of the full bench had not come to any conclusion that the information was exempt. In fact, in some sentences, they say this information should be made available, but Deputy Governor of Reserve Bank says it should not be given. Therefore, we are agreeing that it should not be given. Two, it was a review of an earlier decision by Professor Ansari saying that information should be given, which powers of review the Commission doesn't have.
No.
I had held that the decision is per incurium, and the Supreme Court has taken note of it and said, the Commissioner said it is per incurium, then they don't comment on it. So the Supreme Court was aware of it when they upheld the decision of the Commission.
Correct.
But on fiduciary, he also contends that this is information in a fiduciary relationship. What do you think, sir?
Absolutely. If it is because it is fiduciary, you should give. You can't use fiduciary for concealing the information. The information, again, the point here is the point I raised before TTD. Your money is not your money. It is public money. You are a manager. You are at the most a trustee. So you are supposed to manage the finances of the nation for the benefit of the nation, for the benefit of the general public. And if one member of the general public is having a doubt about its management, you have a duty to clarify it. And such a doubt, which is statutorily converted into a right in 2005 as a right to information petition, you cannot deny it. And being a public authority, you cannot deny it. And all the objections, all the grounds, all the fictitious grounds, baseless grounds, illogical grounds, illegal grounds were taken up to Supreme Court. Supreme Court examined each and every point in a very, very exhaustive manner and came to a conclusion that all those grounds collapse. And you don't have a ground to stand. All the grounds are collapsed. So where are you? How can you say that I don't give this information? And that is the point I tried to use in one of the second appeals that was before me, where I stated that I did not consider PIO as not responsible for the denial of information because he is following the directive of Board of Governors. And the Board of Governors issued a resolution saying that these are the information which I don't want to give. When it is so clear that the governor and other board members are refusing to honor the judgment of the Supreme Court in Jayanti Lal case, how can I issue notice to a PIO? He is a helpless executor of the orders of the higher officers. Then writing all this, I issued a notice to the governor of Reserve Bank of India deeming him as PIO, because he has a duty to implement the Supreme Court order explaining the Right to Information Act as a public authority, and he should give enough power to, they should give enough power to PIO to implement the order and the RTI. So that was the point. So you reviewing it, rescinding it, cancelling it, these are all absolutely new things which law never knew. For example, sir, the banks have filed a petition before the Supreme Court to cancel the judgment of Supreme Court. How can anybody cancel the Supreme Court? No, Constitution never talked about it. There is no remedy called cancellation. There is a curative petition, there is a review petition, but that's all. There ends the matter. Thereafter, it gets finalized. Topmost final law laid down by the Supreme Court, and they have to implement it. But yet they are fighting, yet they are engaging the private banks to question the notices issued by the RBI. These are all absolutely sad state of affairs.
There's an interesting anecdote about you had ordered that the PM's education degree should be given. Would you like to share some information about it?
It is like an RTI petition, sir, and as a commissioner, I have to order for disclosure, so I will definitely disclose. Sir, a person gets into a professional course after writing a public entrance examination. And then he will be studying that course along with 60 students minimum. And every examination is a public examination, and every result is a public document. And it is published in newspapers and notified on the notice boards. And then at the end of the graduation, a ceremony is performed. And in that ceremony, you have to take an oath that you will be you are conducting yourself as a worthy candidate to have this degree. That is the Chancellor Administration, none other than Chancellor. Chancellor means head of the state. Head of the state administers oath, and you are supposed to stand and say, I do. I say, you have to promise that I do. These are all public affairs, sir. Total, complete public affairs. Anybody can verify whether Professor Sridhar has really passed LLB, whether he has really got gold medal in LLB, whether he really got 4 gold medals in MCJ. Anybody can go and verify. They have a right to verify. It is not my private information, because gold medal is not given by my father. It was given by the university. And the money spent for making that gold medal is contributed by public in general. So how can my degree be a private information of mine? Whether I'm Prime Minister or a peon, whether I'm an information commissioner or a teacher, my degree is public information.
Do you know where the case is now?
Delhi High Court, sir, pending.
Okay. So 10 years in Delhi High Court.
10 years, some more years to go, perhaps.
Okay. Sir, the pendencies in the commissions are mounting. And now a lot of commissions, the hearings are held after 2 years and 3 years. At this rate, in another 5 years, the pending will be 5 years. Do you think we are making right to information to right to history act?
Absolutely.
And what is the solution? And what is the solution?
We are going to collapse under the weight of pending cases. It's a very pessimistic view, if I say so, but it appears to be so. I'm surprised even now some of the commissioners, I don't know about Central Information Commission, but I came to know about some state information commissioners. They don't hold the hearings regularly. If a commissioner doesn't hold the trials hearings regularly, pendency will naturally increase. This position is not for enjoyment. It is not for a post-retirement privileged luxury. It is for performing a public duty. So first point I would like to say is the age of the commissioner should not be, or it should not be used to bring in only retired bureaucrats. That is not correct. And because of that, the pendency is increasing. They are sometimes, even though they wanted to hear, they may not be in a position, physically fit position to hear the cases. So my request is there should be an examination for information commissioners, and when those who pass the examination are those who prove their merit, and they should be made information commissioner. There should be amendment to the Right to Information Act. But I hesitate to ask for amendment to the Right to Information Act because it will be totally written out. So I don't ask for it. But at least I suggest to the governments to implement the present law without amending it by appointing information commissioners who are of enthusiasm to hear the cases at least and understand RTI at least and recognize their legitimate duty to discharge dispose of the petitions in a regular way until they complete 5 years of their, whatever, not 5 years, now 3 years of term. That is very, very important.
Lastly, before we go into the question and answer session, where do you think RTI will be 10 years from now? What is your forecast?
Sir, unless more and more people join in it and take as a challenge to file RTI questions and make it a habit for the public information officers to give information. Unless you cultivate a habit of disclosure to the public authorities, unless people massively involved in this mission as a mission, as a movement, very difficult to save the Right to Information Act. Very difficult. Because judiciary is also adding so many caveats, so many limitations, so many restrictions on the RTI. To take the example of Subhash Chandra Agarwal's judgment, in the judgment of Supreme Court in Subhash Chandra Agarwal case in 2019, the Supreme Court went into detailed commentary on right to information. Generally, we authors do that. We sit down and write commentary on that and get published one book. But Supreme Court took out a lot of its time and made a very good analysis. But most of the observations of the Supreme Court now became precedent. They are precedents. They became ratio of the judgment, and every PIO will be guided by this ratio. If that is the case, sir, discretion of the PIOs was enormously increased by the Supreme Court judgment. Instead of confining themselves to the issues that were raised before it, in that case, they went beyond and expressed their own opinions. Except Chandrachud's, Dhananjaya Chandrachud's the perfect analysis, the other observations are a little problematic. and the practical utility of the RTI could suffer seriously because of that. So if at all PIOs have to draw some inspiration about the application of their mind and discretion in deciding the disclosure or non-disclosure of the RTI applications, they should study only Chandrachud's judgment. It is my request. Read dissent, or though it is conquering, a separate judgment was given by Chandrachud. I request all PIOs to read it. And I also request all the RTI activists to support that kind of analysis and criteria and oppose the other criteria, which is not in tune with the spirit of Right to Information Act. And also it's also not in tune with freedom of speech and expression, in the rubric of which you have right to information.
Thank you very much, Sridhar. It's always a pleasure chatting with you. And I keep picking your brains quite often. Thank you very much. Now I'll ask Arvind, have you got a list of people who raised hands, Arvind?
Yes, sir. We have Commodore Lokesh Batra, who's here, who's raised his hand.
Okay.
I'm going to request sir to unmute and share his question. Sir, over to you.
He's from the other side of the world.
My greetings to you all from USA. And such a nice conversation we hear every 15 days, thanks to Moneylife. I mean, my gratitude to Moneylife. Two quick observations I'm making it on the discussion. One is that PM degree case was not only this, it was mentioned in the parliament during the amendment of RTI rule discussion. I think Jairam Ramesh mentioned why government is amending it is because of that issue of a PM degree. This was recorded, it's available. Second part was on PM care funds, which Shailesh has raised the issue. Now, we are justifying so far that money is being collected by the various government authorities, and both India and abroad, entire government machinery is being used. In RTI response by the Commissioner of Income Tax on the exemption category, say it is control and all that, but money is not coming through. That's the only issue they talked. And I started calling it akin to an NGO. But the fact I'm going to tell you is now, during COVID time, some money has been allotted time to time through PIB release. Now it's a PM PIB release, mind it, that PM Care Fund will be giving it. Now think of it, PIB release is for government people and it's a Prime Minister PIB. If that is not enough, all expenditure, whether it was ventilators, whether it's oxygen plants, whether it is vaccines, for which money has been allotted by the PM Care Fund, has been expended through the government. Ventilators, all average, Ministry of Health and Family Welfare. All the government agencies en route till the order is placed by the government agencies. Same is vaccine.
Lokesh, a little shorter, please.
Observation on that, so the more people are aware about this. So that is the second point, is not only collection of fund, it is an expenditure collection of fund, where the entire government machinery is being used, and the funds like public cash and the non-public cash like PM Care Fund is being merged at a different situation. That's the point I was saying.
Okay, any other queries? Please limit it to 60 seconds so that we can, I think Suchita wants to say something.
Yes, Suchita ma'am had a query. I think, ma'am, can you share?
Yeah. Small query, Sridharji. You know, we had a big discussion on what to do about RBI, and we know that the banks are back in court wanting to cancel the judgment. What do you think we as people can do? We've written about the inspection reports that have been released so far. I think Moneylife is the only one that has put out. And those inspection reports show two things. One is that there are no names mentioned. So banks talking about privacy, it's mischievous because it's not true. They have redacted everything. Okay. And on the broader issue, it's very clear that, you know, there is a need for this information, as you said, to be in the public domain. Do you have any suggestions on what is it that we, the people, or, you know, we as activists, savers, investors can do to oppose it? Can it only be that there is somebody with a PIL and he gets attacked with very expensive lawyers and that's the end of the story?
First of all, I think we have to enlist the services of good lawyers who can defend our cases. We have to intervene, and then we have to defend the Right to Information Act. That is under the judgment of Supreme Court in Jayantila. That is the first course of action we should think about. And the second, we should raise such RTI requests in every relevant way. Wherever there is a need for information, we should not hesitate in raising the RTI questions. We should go on doing it. It should be like a movement. I think these are the two things which will increase the pressure on the banks and regulatories to have some system of giving information. So we have to make them to do it. We have to compel them. We have to raise a pressure group. We have to organize a pressure group through legal processes and the social processes also. We should think about it. This is the idea all of a sudden that I can say, impromptu idea that I can give, but we can think about it and we have to do something. And you are doing it. You are doing it, and it has to be done by all. In every city, it has to be done.
We have people who have raised their hands. So I'm going to request Dr. Amitra Sudan. Dr. Amitra, can you please unmute?
Yes, sir.
Dr. Amitra, I'm going to request you to keep your question really precise. We don't have a lot of time for long
60
questions.
seconds, please, Amitra.
Yeah.
Yes, sir. Yes, sir. Yes, sir. Very good evening to all the dignitaries, Shailesh sir and Professor Acharyulu sir. My question is that in my last 15 years experience, I found that if the appellate authority orders the SPIO to supply the information, but SPIO or CPIO deliberately violates the order of the appellate authority, first appellate authority. And when I have written that first appellate authority remains silent when I ask that you please take steps to implement your own order, because the Department of Personnel and Training guidebook for the first appellate authority, it is mentioned that it is the duty of the first appellate authority to enforce its own order. Basically, it is the duty of the authority who is passing the order to enforce its own order. So how I can proceed here? I thought of that I can approach the higher authority to take a disciplinary action against the first appellate authority. So you know that higher authority will remain negligent to take an initiative, and I am not in a position to take the matter before the court, because as I said that hiring the lawyer, etc. are involved. So what other avenues are open in this regard? So I want your advice, sir.
First of all, you have to keep on writing letters, representations, petitions. You have to raise the level of questioning and then file petitions before the appropriate authorities. That is one way. Hold press conferences and talk about it loudly, and then do certain dharnas, because they are non-legal processes. I'm not saying illegal, I'm saying non-legal processes. So you have to do all these things. See, you are damn sure that there is an order of disclosure by the appellate authority not being implemented. Then what to do? There are all things to do. And if you have any pro bono lawyer available, please file a writ petition also.
And Dr. Amrita, one suggestion. My submission is, before a commissioner, when you go for a second appeal, insist that compensation should be given to you, penalty should be levied on the PIO, and disciplinary action should be recommended. These are minimum conditions when a first appellate authority's order is disobeyed.
And file a complaint before the commission. Complaint also.
Okay. Can I request Mr. B. Khanna to unmute?
I am referring to an RTI application and the judgment of CIC, where the sir only had passed an order for IBA to be declared as a public authority, Indian Banks Association. Now, Delhi High Court gave an ex parte stay to IBA without listening the other party. And this case is pending for the last 4 years now, thanks to COVID and thanks to the normal procedures of delaying justice. What should be done? Because unfortunately, the RTI activist, Mr. R.K. Jain, is no more in the world. And normally this is what happens. I happen to represent the other the party, the Ita Bose. Sir may remember the case. And I represented him. I represented Ita Bose before you, sir. please guide us, because my advocate also is not able to guide me. So if you can throw some light on this.
Sir, I was talking to Mr. Shailesh Gandhi yesterday and today morning also. The 227 itself contains a provision according to which the life of stay is very, very, very small period. And the Supreme Court in recent times, in 2018, perhaps 18, February or March, they gave a very good judgment that that says a stay cannot operate for more than 60 days, and if the stay is not revived, it will collapse. It will collapse within 60 days. So again, the remedy is a legal remedy, appears to be legal remedy. You have to enlist some pro bono lawyer support. You have to advocate for it, or collect some money and do it, and question it, accelerate the hearing of the case, or ask for the declaration that stay has collapsed. And IBA should act as a public authority. Ask for it. Or file an RTI application before IBA, rejects it, file a complaint before CIC. So use all the processes that are available around.
Can I request Mr. Altaf to unmute? Mr. Altaf?
In Maharashtra, a lot of activists murdered by criminals because of one issue. They file. So how to protect activists in India?
It's a very big question. It's a very sad situation also. One way why I think about it is, there is a provision for not disclosing the name and the address. So the people who are going to raise troublesome questions, or I can say, if your RTA request is going to be a very serious problem, better you do not disclose your name and try to protect your name, try to defend yourself. So prevention is important. This is one thing. Secondly, there is absolutely lacunae in the mechanism, and there is laziness and scant regard for the human lives in this country. And people, when they are getting threatened, getting murdered, they are not. There is no response from the mechanism. So it's a general issue, also specifically a problem for the RTI activists. So we have to protect the RTA things, and government protection, I don't think is really a protection. So a social protection, a civil society uprising, or a strong pressure group demanding for this security of our immediate action against the culprits has to be there. A strong advocacy has to be continuously raised.
One other thing you can try is, when you think something is likely to result into a very messy situation, get people from another city or another state to file the RT applications. Another technique that is used is 8 or 10 people file the same RT application. Correct. And it is not very easy for somebody to threaten 10 people or bring harm to 10 people.
Mr. Subhash Kataria is here. Mr. Subhash, I'm going to request you to unmute. Please keep your question precise.
Yeah. So, Commissioner is supposed to expose wrongdoings with the help of documents. What do you do when Commissioner helps in suppressing the wrongdoing of documents? I'm facing to a specific case. I spoke to Shailesh Bhai also on this. He advised me to go to court. I've gone to High Court. But what do you do when I give evidence of wrongdoing in the hand of the Commissioner, and the mockery of a right to abuse the Information Act as indulged by the PIO, who is the culprit in the entire matter, who has acted against the state government, and Commissioner is trying to suppress all this by passing a judgment against me, making my appeals void. That I made too many appeals, and PIO is not going to give information against his own self ever. You do not expect the PIO to give papers against himself, and this is happening at the highest level of the government organization. And Commissioner is part of such an act, which is very, in my words, shameful. So the Commissioner is not picking up my appeals. Wrong affidavits are there. I've given application for perjury. They're not even listening to the application for perjury. Is he the right authority to listen to perjury on his own affidavits or no?
This squarely amounts to misconduct. If a commissioner has done it, and you come on, initiate proceedings against misconduct.
Sir, RTI says that only 2 instances of documents are missing, and both the documents are mine from Commissioner's office, given in his hand.
And he suppresses it. So that's what I'm saying. It squarely falls under the definition of misconduct, which is a ground for removal. My suggestion is initiate the process. Whether it gets removed or not, at least people understand that there is a process like this is available and people may question it. So please initiate that. I'd like to give you an example. When I was a lecturer in a private law college, an IAS officer was writing an examination, an LLB examination in my college. Then he was copying. He's not only an IAS officer, but he was also Public Service Commission member. A Public Service Commission member who is supposed to conduct examinations fairly and select meritorious people to the government offices, he himself was copying. Then I caught. I did not fear. I organized and I took all the care so that nothing will go wrong. And I got him caught, and I reported to the university immediately without giving any time for anybody to review or withdraw it. So I did it in a jet speed. Then I faced lots of problems because of that. But because of this copying, his misconduct was established and he was removed from the commission's position. It is, Shailesh, this is one more adventure of my life.
In my case, the beneficiaries for wrongful acts are some of the biggest industrialists in India.
True.
Their families.
So that's what, sir. We have to use all the provisions available in the law, but I'm not sure whether it will really result in. But at least there will be a serious public discussion. People come to know that this fellow is doing like this. That is a real punishment.
Thank you very much, Sridhar, and thanks to all the participants and to Moneylife for supporting RTI activity like this. And to you, Sridhar, all the very best as Dean of Mahendra University. I'm sure you will do wonders there, like you did in RTI, and you were a godsend for RTI. We wish we had more commissioners like you. Thank you very much.
Thank you, sir. Thank you for the wonderful opportunity.